Ancient Law its connection with the early history of society and its relation to modern ideas by Sir Henry Sumner Maine. Ancient Law its connection with the early history of society and its relation to modern ideas by Sir Henry Sumner Maine. Chapter 3 and 4. Chapter 3 Law of Nature and Equity. The theory of a set of legal principles entitled by their intrinsic superiority to supersede the older law, very early obtained currency both in the Roman state and in England. Such a body of principles, existing in any system, has in the foregoing chapters been denominated equity, a term which, as will presently be seen, was one, though only one, of the designations by which this agent of legal change was known to the Roman jurisconsults. The jurisprudence of the Court of Chancery, which bears the name of equity in England, could only be adequately discussed in a separate treatise. It is extremely complex in its texture, and derives its materials from several heterogeneous sources. The early ecclesiastical chancellors contributed to it, from the canon law, many of the principles which lie deepest in its structure. The Roman law, more fertile than the canon law in rules applicable to secular disputes, was not seldom resorted to by a later generation of chancery judges, amid whose recorded dicta we often find entire texts from the Corpus Juris Civilis embedded, with their terms unaltered, though their origin is never acknowledged. Still more recently, and particularly at the middle and during the latter half of the 18th century, the mixed systems of jurisprudence and morals constructed by the publicists of the Low Countries appear to have been much studied by English lawyers, and from the chancellorship of Lord Talbot to the commencement of Lord Eldon's chancellorship these works had considerable effect on the rulings of the Court of Chancery. The system, which obtained its ingredients from these various quarters, was greatly controlled in its growth by the necessity imposed on it of conforming itself to the analogies of the common law, but it has always answered the description of a body of comparatively novel legal principles claiming to override the older jurisprudence of the country on the strength of an intrinsic ethical superiority. The equity of Rome was a much simpler structure, and its development from its first appearance can be much more easily traced. Both its character and its history deserve attentive examination. It is the root of several conceptions which have exercised profound influence on human thought, and through human thought have seriously affected the destinies of mankind. The Romans described their legal system as consisting of two ingredients. All nations, says the institutional treatise published under the authority of the Emperor Justinian, who are ruled by laws and customs, are governed partly by their own particular laws, and partly by those laws which are common to all mankind. The law which a people enacts is called the civil law of that people, but that which natural reason appoints for all mankind is called the law of nations, because all nations use it. The part of the law which natural reason appoints for all mankind was the element which the edict of the praetor was supposed to have worked into Roman jurisprudence. Elsewhere it is styled more simply jus naturale, or the law of nature, and its ordinances are said to be dictated by natural equity, naturalis equitas, as well as by natural reason. I shall attempt to discover the origin of these famous phrases, law of nations, law of nature, equity, and to determine how the conceptions which they indicate are related to one another. The most superficial student of Roman history must be struck by the extraordinary degree in which the fortunes of the Republic were affected by the presence of foreigners, under different names, on her soil. The causes of this immigration are discernible enough at a later period, for we can readily understand why men of all races should flock to the mistress of the world. But the same phenomenon of a large population of foreigners and denizens meets us in the very earliest records of the Roman state. No doubt, the instability of society in ancient Italy, composed as it was in great measure of robber tribes, gave men considerable inducement to locate themselves in the territory of any community strong enough to protect itself and them from external attack. Even though protection should be purchased at the cost of heavy taxation, political disfranchisement, and much social humiliation, it is probable, however, that this explanation is imperfect, and that it could only be completed by taking into account those active commercial relations which, though they are little reflected in the military traditions of the Republic, Rome appears certainly to have had with Carthage and with the interior of Italy in prehistoric times. Whatever were the circumstances to which it was attributable, the foreign element in the Commonwealth determined the whole course of its history. which, at all its stages, is little more than a narrative of conflicts between a stubborn nationality and an alien population. Nothing like this has been seen in modern times, on the one hand, because modern European communities have seldom or never received any accession of foreign immigrants which was large enough to make itself felt by the bulk of the native citizens, and on the other, because modern states, being held together by allegiance to a king or political superior, absorb considerable bodies of immigrant settlers with a quickness unknown to the ancient world, where the original citizens of a commonwealth always believed themselves to be united by kinship in blood, and resented a claim to equality of privilege as a usurpation of their birthright. In the early Roman Republic, the principle of the absolute exclusion of foreigners pervaded the civil law no less than the constitution. The alien or denizen could have no share in any institution supposed to be coeval with the state. He could not have the benefit of quiritarian law. He could not be a party to the nexum which was at once the conveyance and the contract of the primitive Romans. He could not sue by the sacramental action, a mode of litigation of which the origin mounts up to the very infancy of civilization. Still, neither the interest nor the security of Rome permitted him to be quite outlawed. All ancient communities ran the risk of being overthrown by a very slight disturbance of equilibrium, and the mere instinct of self-preservation would force the Romans to devise some method of adjusting the rights and duties of foreigners, who might otherwise, and this was a danger of real importance in the ancient world, have decided their controversies by armed strife. Moreover, at no period of Roman history was foreign trade entirely neglected. It was therefore probably half as a measure of police and half in furtherance of commerce that jurisdiction was first assumed in disputes to which the parties were either foreigners or a native and a foreigner. The assumption of such a jurisdiction brought with it the immediate necessity of discovering some principles on which the questions to be adjudicated upon could be settled, and the principles applied to this object by the Roman lawyers were eminently characteristic of the time. They refused, as I have said before, to decide the new cases by pure Roman civil law. They refused, no doubt because it seemed to involve some kind of degradation, to apply the law of the particular state from which the foreign litigant came. The expedient to which they resorted was that of selecting the rules of law common to Rome and to the different Italian communities in which the immigrants were born. In other words, they set themselves to form a system answering to the primitive and literal meaning of jus gentium, that is, law common to all nations. Jus gentium was, in fact, the sum of the common ingredients in the customs of the old Italian tribes, for they were all the nations whom the Romans had the means of observing, and who sent successive swarms of immigrants to Roman soil. Whenever a particular usage was seen to be practiced by a large number of separate races in common, it was set down as part of the law common to all nations, or jus gentium. Thus, although the conveyance of property was certainly accompanied by very different forms in the different commonwealths surrounding Rome, the actual transfer, tradition, or delivery of the article intended to be conveyed was a part of the ceremonial in all of them. It was, for instance, a part, though a subordinate part, in the emancipation or conveyance peculiar to Rome. Tradition, therefore, being in all probability the only common ingredient in the modes of conveyance which the jurisconsults had the means of observing, was set down as an institution juris gentium, or rule of the law common to all nations. A vast number of other observances were scrutinized with the same result. Some common characteristic was discovered in all of them, which had a common object, and this characteristic was classed in the jus gentium. The jus gentium was accordingly a collection of rules and principles, determined by observation to be common to the institutions which prevailed among the various Italian tribes. The circumstances of the origin of the jus gentium are probably a sufficient safeguard against the mistake of supposing that the Roman lawyers had any special respect for it. It was the fruit in part of their disdain for all foreign law, and in part of their disinclination to give the foreigner the advantage of their own indigenous jus civil. It is true that we, at the present day, should probably take a very different view of the jus gentium, If we were performing the operation which was effected by the Roman jurisconsults, we should attach some vague superiority or precedence to the element which we had thus discerned underlying and pervading so great a variety of usage. We should have a sort of respect for rules and principles so universal. Perhaps we should speak of the common ingredient as being of the essence of the transaction into which it entered, and should stigmatize the remaining apparatus of ceremony, which varied in different communities, as adventitious and accidental. Or it may be, we should infer that the races which we were comparing once obeyed a great system of common institutions of which the jus gentium was the reproduction, and that the complicated usages of separate commonwealths were only corruptions and deprivations of the simpler ordinances which had once regulated their primitive state. But the results to which modern ideas conduct the observer are, as nearly as possible, the reverse of those which were instinctively brought home to the primitive Roman. What we respect or admire, he disliked or regarded with jealous dread. The parts of jurisprudence which he looked upon with affection were exactly those which a modern theorist leaves out of consideration as accidental and transitory: the solemn gestures of the emancipation, the nicely adjusted questions and answers of the verbal contract, the endless formalities of pleading and procedure. The jus gentium was merely a system forced on his attention by a political necessity. He loved it as little as he loved the foreigners from whose institutions it was derived and for whose benefit it was intended. A complete revolution in his ideas was required before it could challenge his respect, but so complete was it when it did occur, that the true reason why our modern estimate of the jus gentium differs from that which has just been described, is that both modern jurisprudence and modern philosophy have inherited the matured views of the later jurisconsults on this subject. There did come a time when, from an ignoble appendage of the jus civile, the jus gentium came to be considered a great though as yet imperfectly developed model to which all law ought as far as possible to conform. This crisis arrived when the Greek theory of a law of nature was applied to the practical Roman administration of the law common to all nations. The jus naturale, or law of nature, is simply the jus gentium or law of nations seen in the light of a peculiar theory. An unfortunate attempt to discriminate them was made by the jurisconsult Ulpian, with the propensity to distinguish characteristic of a lawyer, but the language of Gaius, a much higher authority, and the passage quoted before from the Institutes, leave no room for doubt that the expressions were practically convertible. The difference between them was entirely historical, and no distinction in essence could ever be established between them. It is almost unnecessary to add that the confusion between jus gentium, or law common to all nations, and international law is entirely modern. The classical expression for international law is jus officiale, or the law of negotiation and diplomacy. It is, however, unquestionable that indistinct impressions as to the meaning of jus gentium had considerable share in producing the modern theory that the relations of independent states are governed by the law of nature. It becomes necessary to investigate the Greek conceptions of nature and her law. The word averts, which was rendered in the Latin naturo and our nature, denoted beyond all doubt originally the material universe, but it was the material universe contemplated under an aspect which, such is our intellectual distance from those times, it is not very easy to delineate in modern language. Nature signified the physical world regarded as the result of some primordial element or law. The oldest Greek philosophers had been accustomed to explain the fabric of creation as the manifestation of some single principle which they variously asserted to be movement, fire, moisture, or generation. In its simplest and most ancient sense, nature is precisely the physical universe looked upon in this way as the manifestation of a principle. Afterwards, the later Greek sects, returning to a path from which the greatest intellects of Greece had meanwhile strayed, added the moral to the physical world in the conception of nature. They extended the term till it embraced not merely the visible creation, but the thoughts, observances, and aspirations of mankind. Still, as before, it was not solely the moral phenomena of human society which they understood by nature, but these phenomena considered as resolvable into some general and simple laws. Now, just as the oldest Greek theorists supposed that the sports of chance had changed the material universe from its simple primitive form into its present heterogeneous condition, So their intellectual descendants imagined that but for untoward accident the human race would have conformed itself to simpler rules of conduct and a less tempestuous life. To live according to nature came to be considered as the end for which man was created, and which the best men were bound to compass. To live according to nature was to rise above the disorderly habits and gross indulgences of the vulgar to higher laws of action which nothing but self-denial and self-command would enable the aspirant to observe. It is notorious that this proposition, live according to nature, was the sum of the tenets of the famous Stoic philosophy. Now on the subjugation of Greece, that philosophy made instantaneous progress in Roman society. It possessed natural fascinations for the powerful class who, in theory at least, adhered to the simple habits of the ancient Italian race, and disdained to surrender themselves to the innovations of foreign fashions. Such persons began immediately to affect the Stoic precepts of life according to nature, an affectation all the more grateful, and, I may add, all the more noble, from its contrast with the tin-bounded profligacy which was being diffused through the imperial city by the pillage of their world and by the example of its most luxurious races. In the front of the disciples of the new Greek school, we might be sure, even if we did not know it historically, that the Roman lawyers figured. We have abundant proof that, there being substantially but two professions in the Roman Republic, the military men were generally identified with the party of movement, but the lawyers were universally at the head of the party of resistance. The alliance of the lawyers with the Stoic philosophers lasted through many centuries. Some of the earliest names in the series of renowned jurisconsults are associated with Stoicism, and ultimately we have the golden age of Roman jurisprudence fixed by general consent as the era of the Antonine Caesars, the most famous disciples to whom that philosophy has given a rule of life. The long diffusion of these doctrines among the members of a particular profession was sure to affect the art which they practiced and influenced. Several positions which we find in the remains of the Roman jurisconsults are scarcely intelligible, unless we use the Stoic tenets as our key, but at the same time it is a serious, though a very common, error to measure the influence of Stoicism on Roman law by counting up the number of legal rules which can be confidently affiliated on Stoical dogmas. It has often been observed that the strength of Stoicism resided not in its canons of conduct, which were often repulsive or ridiculous, but in the great though vague principle which it inculcated of resistance to passion. Just in the same way the influence on jurisprudence of the Greek theories, which had their most distinct expression in Stoicism, consisted not in the number of specific positions which they contributed to Roman law, but in the single fundamental assumption which they lent to it. After nature had become a household word in the mouths of the Romans, the belief gradually prevailed among the Roman lawyers that the old jus gentium was in fact the lost code of nature, and that the praetor in framing an edictal jurisprudence on the principles of the jus gentium was gradually restoring a type from which law had only departed to deteriorate. The inference from this belief was immediate that it was the praetor's duty to supersede the civil law as much as possible by the edict, to revive as far as might be the institutions by which nature had governed man in the primitive state. Of course there were many impediments to the amelioration of law by this agency. There may have been prejudices to overcome even in the legal profession itself, and Roman habits were far too tenacious to give way at once to mere philosophical theory. The indirect methods by which the edict combated certain technical anomalies, show the caution which its authors were compelled to observe. And down to the very days of Justinian there was some part of the old law which had obstinately resisted its influence. But on the whole, the progress of the Romans in legal improvement was astonishingly rapid as soon as stimulus was applied to it by the theory of natural law. The ideas of simplification and generalization had always been associated with the conception of nature. Simplicity, symmetry, and intelligibility came therefore to be regarded as the characteristics of a good legal system, and the taste for involved language, multiplied ceremonials, and useless difficulties disappeared altogether. The strong will and unusual opportunities of Justinian were needed to bring the Roman law to its existing shape, but the ground plan of the system had been sketched long before the imperial reforms were effected. What was the exact point of contact between the old jus gentium and the law of nature? I think that they touch and blend through equitas, or equity in its original sense, And here we seem to come to the first appearance in jurisprudence of this famous term equity. In examining an expression which has so remote an origin and so long a history as this, it is always safest to penetrate, if possible, to the simple metaphor or figure which at first shadowed forth the conception. It has generally been supposed that skytis is the equivalent of the Greek 10:07779, that is, the principle of equal or proportionate distribution. The equal division of numbers or physical magnitudes is doubtless closely entwined with our perceptions of justice. There are few associations which keep their ground in the mind so stubbornly or are dismissed from it with such difficulty by the deepest thinkers. Yet in tracing the history of this association, it certainly does not seem to have suggested itself to very early thought, but is rather the offspring of a comparatively late philosophy. It is remarkable too that the equality of laws on which the Greek democracies prided themselves, that equality which, in the beautiful drinking song of Falstratus, Harmodius and Aristogiton are said to have given to Athens, had little in common with the equity of the Romans. The just was an equal administration of civil laws among the citizens, however limited the class of citizens might be. The last implied the applicability of a law, which was not civil law, to a class which did not necessarily consist of citizens. The first excluded a despot. The last included foreigners, and for some purposes slaves. On the whole, I should be disposed to look in another direction for the germ of the Roman equity. The Latin word sequus carries with it more distinctly than the Greek 1009 the sense of leveling. Now its leveling tendency was exactly the characteristic of the jus gentium, which would be most striking to a primitive Roman. The pure quiritarian law recognized a multitude of arbitrary distinctions between classes of men and kinds of property. The jus gentium, generalized from a comparison of various customs, neglected the quiritarian divisions. The old Roman law established, for example, a fundamental difference between agnatic and cognatic relationship, that is, between the family considered as based upon common subjection to patriarchal authority and the family considered, in conformity with modern ideas, as united through the mere fact of a common descent. This distinction disappears in the law common to all nations, as also does the difference between the archaic forms of property, things mancipi and things ne mancipi. The neglect of demarcations and boundaries seems to me, therefore, the feature of the jus gentium which was depicted in Equitis. I imagine that the word was at first a mere description of that constant leveling or removal of irregularities which went on wherever the praetorian system was applied to the cases of foreign litigants. Probably no color of ethical meaning belonged at first to the expression, nor is there any reason to believe that the process which it indicated was otherwise than extremely distasteful to the primitive Roman mind. On the other hand, the feature of the gentium which was presented to the apprehension of a Roman by the word equity, was exactly the first and most vividly realized characteristic of the hypothetical state of nature. Nature implied symmetrical order, first in the physical world, and next in the moral, and the earliest notion of order doubtless involved straight lines, even surfaces, and measured distances. The same sort of picture or figure would be unconsciously before the mind's eye, whether it strove to form the outlines of the supposed natural state, or whether it took in at a glance the actual administration of the law common to all nations, and all we know of primitive thought would lead us to conclude that this ideal similarity would do much to encourage the belief in an identity of the two conceptions. But then, while the jus gentium had little or no antecedent credit at Rome, the theory of a law of nature came in surrounded with all the prestige of philosophical authority, and invested with the charms of association with an elder and more blissful condition of the race. It is easy to understand how the difference in the point of view would affect the dignity of the term which at once described the operation of the old principles and the results of the new theory. Even to modern ears it is not at all the same thing to describe a process as one of leveling and to call it the correction of anomalies, though the metaphor is precisely the same. Nor do I doubt that, when once equitis was understood to convey an allusion to the Greek theory, associations which grew out of the Greek notion of ektotes began to cluster round it. The language of Cicero renders it more than likely that this was so, and it was the first stage of a transmutation of the conception of equity, which almost every ethical system which has appeared since those days has more or less helped to carry on. Something must be said of the formal instrumentality by which the principles and distinctions associated, first with the law common to all nations, and afterwards with the law of nature, were gradually incorporated with the Roman law. At the crisis of primitive Roman history, which is marked by the expulsion of the Tarquins, a change occurred which has its parallel in the early annals of many ancient states, but which had little in common with those passages of political affairs which we now term revolutions. It may best be described by saying that the monarchy was put into commission. The powers heretofore accumulated in the hands of a single person were parcelled out among a number of elective functionaries, the very name of the kingly office being retained and imposed on a personage known subsequently as the Rex Sacrarum or Rex Sacrificulus. As part of the change, the settled duties of the supreme judicial office devolved on the praetor, at the time the first functionary in the Commonwealth, and together with these duties was transferred the undefined supremacy over law and legislation which always attached to ancient sovereigns, and which is not obscurely related to the patriarchal and heroic authority they had once enjoyed. The circumstances of Rome give great importance to the more indefinite portion of the functions thus transferred. As with the establishment of the Republic began that series of recurrent trials which overtook the state, in the difficulty of dealing with the multitude of persons who, not coming within the technical description of indigenous Romans, were nevertheless permanently located within Roman jurisdiction. Controversies between such persons, or between such persons and native-born citizens, would have remained without the pale of the remedies provided by Roman law, if the praetor had not undertaken to decide them, and he must soon have addressed himself to the more critical disputes which in the extension of commerce arose between Roman subjects and avowed foreigners. The great increase of such cases in the Roman courts about the period of the First Punic War is marked by the appointment of a special praetor, known subsequently as the Praetor Peregrinus, who gave them his undivided attention. Meantime, one precaution of the Roman people against the revival of oppression had consisted in obliging every magistrate whose duties had any tendency to expand their sphere, to publish, on commencing his year of office, an edict or proclamation in which he declared the manner in which he intended to administer his department. The praetor fell under the rule with other magistrates, but as it was necessarily impossible to construct each year a separate system of principles, he seems to have regularly republished his predecessor's edict with such additions and changes as the exigency of the moment or his own views of the law compelled him to introduce. The praetor's proclamation, thus lengthened by a new portion every year, obtained the name of the Edictum Perpetuum, that is the continuous or unbroken edict. The immense length to which it extended, together perhaps with some distaste for its necessarily disorderly texture, caused the practice of increasing it to be stopped in the year of Salvius Julianus, who occupied the magistracy in the reign of the Emperor Hadrian. The edict of that praetor embraced therefore the whole body of equity jurisprudence, which it probably disposed in new and symmetrical order, and the perpetual edict is therefore often cited in Roman law merely as the Edict of Julianus. Perhaps the first inquiry which occurs to an Englishman who considers the peculiar mechanism of the edict is, what were the limitations by which these extensive powers of the praetor were restrained? How was authority so little definite to be reconciled with a settled condition of society and of law? The answer can only be supplied by careful observation of the conditions under which our own English law is administered. The praetor, it should be recollected, was a jurisconsult himself, or a person entirely in the hands of advisers who were jurisconsults, and it is probable that every Roman lawyer waited impatiently for the time when he should fill or control the great judicial magistracy. In the interval, his tastes, feelings, prejudices, and degree of enlightenment were inevitably those of his own order, and the qualifications which he ultimately brought to office were those which he had acquired in the practice and study of his profession. An English chancellor goes through precisely the same training, and carries to the woolsack the same qualifications. It is certain when he assumes office that he will have, to some extent, modified the law before he leaves it, but until he has quitted his seat, and the series of his decisions in the law reports has been completed, we cannot discover how far he has elucidated or added to the principles which his predecessors bequeathed to him. The influence of the Praetor on Roman jurisprudence differed only in respect of the period at which its amount was ascertained. As was before stated, he was in office but for a year, and his decisions rendered during his year, though of course irreversible as regarded the litigants, were of no ulterior value. The most natural moment for declaring the changes he proposed to effect, occurred therefore at his entrance on the praetorship, and hence, when commencing his duties, he did openly and avowedly that which in the end his English representative does insensibly and sometimes unconsciously. The checks on his apparent liberty are precisely those imposed on an English judge. Theoretically there seems to be hardly any limit to the powers of either of them, but practically the Roman praetor, no less than the English chancellor, was kept within the narrowest bounds by the prepossessions imbibed from early training, and by the strong restraints of professional opinion, restraints of which the stringency can only be appreciated by those who have personally experienced them. It may be added that the lines within which movement is permitted, and beyond which there is to be no travelling, were chalked with as much distinctness in the one case as in the other. In England the judge follows the analogies of reported decisions on insulated groups of facts. At Rome, as the intervention of the praetor was at first dictated by simple concern for the safety of the state, it is likely that in the earliest times it was proportioned to the difficulty which it attempted to get rid of. Afterwards, when the taste for principle had been diffused by the responses, he no doubt used the edict as the means of giving a wider application to those fundamental principles which he and the other practicing jurisconsults, his contemporaries, believed themselves to have detected underlying the law. Latterly he acted wholly under the influence of Greek philosophical theories, which at once tempted him to advance and confined him to a particular course of progress. The nature of the measures attributed to Salvius Julianus has been much disputed. Whatever they were, their effects on the edict are sufficiently plain. It ceased to be extended by annual additions, and henceforward the equity jurisprudence of Rome was developed by the labours of a succession of great jurisconsults who fill with their writings the interval between the reign of Hadrian and the reign of Alexander Severus. A fragment of the wonderful system which they built up survives in the Pandects of Justinian, and supplies evidence that their works took the form of treatises on all parts of Roman law, but chiefly that of commentaries on the edict. Indeed, whatever be the immediate subject of a jurisconsult of this epoch, he may always be called an expositor of equitapostrophe. The principles of the edict had, before the epoch of its cessation, made their way into every part of Roman jurisprudence. The equity of Rome, it should be understood, even when most distinct from the civil law, was always administered by the same tribunals. The praetor was the chief equity judge as well as the great common law magistrate, and as soon as the edict had evolved an equitable rule the praetor's court began to apply it in place of or by the side of the old rule of the civil law, which was thus directly or indirectly repealed without any express enactment of the legislature. The result, of course, fell considerably short of a complete fusion of law and equity, which was not carried out till the reforms of Justinian. The technical severance of the two elements of jurisprudence entailed some confusion and some inconvenience, and there were certain of the stubborner doctrines of the civil law with which neither the authors nor the expositors of the edict had ventured to interfere. But at the same time there was no corner of the field of jurisprudence which was not more or less swept over by the influence of equity. It supplied the jurist with all his materials for generalization, with all his methods of interpretation, with his elucidations of first principles, and with that great mass of limiting rules which are rarely interfered with by the legislator, but which seriously control the application of every legislative act. The period of jurists ends with Alexander Severus. From Hadrian to that emperor the improvement of law was carried on, as it is at the present moment in most continental countries, partly by approved commentaries and partly by direct legislation. But in the reign of Alexander Severus the power of growth in Roman equity seems to be exhausted, and the succession of jurisconsults comes to a close. The remaining history of the Roman law is the history of the imperial constitutions, and, at the last, of attempts to codify what had now become the unwieldy body of Roman jurisprudence. We have the latest and most celebrated experiment of this kind in the Corpus Juris of Justinian. It would be wearisome to enter on a detailed comparison or contrast of English and Roman equity, but it may be worthwhile to mention two features which they have in common. The first may be stated as follows. Each of them tended, and all such systems tend, to exactly the same state in which the old common law was when equity first interfered with it. A time always comes at which the moral principles originally adopted have been carried out to all their legitimate consequences, and then the system founded on them becomes as rigid, as unexpansive, and as liable to fall behind moral progress as the sternest code of rules avowedly legal. Such an epoch was reached at Rome in the reign of Alexander Severus, after which, though the whole Roman world was undergoing a moral revolution, the equity of Rome ceased to expand. The same point of legal history was attained in England under the chancellorship of Lord Eldon, the first of our equity judges who, instead of enlarging the jurisprudence of his court by indirect legislation, devoted himself through life to explaining and harmonizing it. If the philosophy of legal history were better understood in England, Lord Eldon's services would be less exaggerated on the one hand and better appreciated on the other than they appear to be among contemporary lawyers. Other misapprehensions, too, which bear some practical fruit, would perhaps be avoided. It is easily seen by English lawyers that English equity is a system founded on moral rules, but it is forgotten that these rules are the morality of past centuries, not of the present, that they have received nearly as much application as they are capable of, and that, though of course they do not differ largely from the ethical creed of our own day, they are not necessarily on a level with it. The imperfect theories of the subject which are commonly adopted have generated errors of opposite sorts. Felony writers of treatises on equity, struck with the completeness of the system in its present state, commit themselves expressly or implicitly to the paradoxical assertion that their founders of the Chancery jurisprudence contemplated its present fixity of form when they were settling its first basis. Others, again, complain, and this is a grievance frequently observed upon in forensic arguments, that the moral rules enforced by the Court of Chancery fall short of the ethical standard of the present day. They would have each Lord Chancellor perform precisely the same office for the jurisprudence which he finds ready to his hand, which was performed for the old common law by the fathers of English equity. But this is to invert the order of the agencies by which the improvement of the law is carried on. Equity has its place and its time, but I have pointed out that another instrumentality is ready to succeed it when its energies are spent. Another remarkable characteristic of both English and Roman equity is the falsehood of the assumptions upon which the claim of the equitable to superiority over the legal rule is originally defended. Nothing is more distasteful to men, either as individuals or as masses, than the admission of their moral progress as a substantive reality. This unwillingness shows itself, as regards individuals, in the exaggerated respect which is ordinarily paid to the doubtful virtue of consistency. The movement of the collective opinion of a whole society is too palpable to be ignored, and is generally too visibly for the better to be decried, but there is the greatest disinclination to accept it as a primary phenomenon, and it is commonly explained as the recovery of a lost perfection, the gradual return to a state from which the race has lapsed. This tendency to look backward instead of forward for the goal of moral progress produced anciently, as we have seen, on Roman jurisprudence effects the most serious and permanent. The Roman jurisconsults, in order to account for the improvement of their jurisprudence by the praetor, borrowed from Greece the doctrine of a natural state of man, a natural society anterior to the organization of commonwealths governed percent y positive laws. In England, on the other hand, a range of ideas especially congenial to Englishmen of that day, explained the claim of equity to override the common law by supposing a general right to superintend the administration of justice which was assumed to be vested in the king as a natural result of his paternal authority. The same view appears in a different and a quainter form in the old doctrine that equity flowed from the king's conscience, the improvement which had in fact taken place in the moral standard of the community being thus referred to an inherent elevation in the moral sense of the sovereign. The growth of the English constitution rendered such a theory unpalatable after a time, but as the jurisdiction of the Chancery was then firmly established, it was not worthwhile to devise any formal substitute for it. The theories found in modern manuals of equity are very various, but all are alike in their untenability. Most of them are modifications of the Roman doctrine of natural law, which is indeed adopted in terms by those writers who begin a discussion of the jurisdiction of the Court of Chancery by laying down a distinction between natural justice and civil. Chapter 4. The modern history of the law of nature. It will be inferred from what has been said that the theory which transformed the Roman jurisprudence had no claim to philosophical precision. It involved, in fact, one of those mixed modes of thought which are now acknowledged to have characterized all but the highest minds during the infancy of speculation, and which are far from undiscoverable even in the mental efforts of our own day. The law of nature confused the past and the present. Logically, it implied a state of nature which had once been regulated by natural law. Yet the jurisconsults do not speak clearly or confidently of the existence of such a state, which indeed is little noticed by the ancients except where it finds a poetical expression in the fancy of a golden age. Natural law, for all practical purposes, was something belonging to the present, something entwined with existing institutions, something which could be distinguished from them by a competent observer. The test which separated the ordinances of nature from the gross ingredients with which they were mingled was a sense of simplicity and harmony. Yet it was not on account of their simplicity and harmony that these finer elements were primarily respected, but on the score of their descent from the aboriginal reign of nature. This confusion has not been successfully explained away by the modern disciples of the jurisconsults. And in truth modern speculations on the law of nature betray much more indistinctness of perception and are vitiated by much more helpless ambiguity of language than the Roman lawyers can be justly charged with. There are some writers on the subject who attempt to evade the fundamental difficulty by contending that the code of nature exists in the future and is the goal to which all civil laws are moving, but this is to reverse the assumptions on which the old theory rested. Or rather perhaps to mix together two inconsistent theories. The tendency to look not to the past but to the future for types of perfection was brought into the world by Christianity. Ancient literature gives few or no hints of a belief that the progress of society is necessarily from worse to better. But the importance of this theory to mankind has been very much greater than its philosophical deficiencies would lead us to expect. Indeed, it is not easy to say what turn the history of thought, and therefore of the human race, would have taken, if the belief in a law natural had not become universal in the ancient world. There are two special dangers to which law, and society which is held together by law, appear to be liable in their infancy. One of them is that law may be too rapidly developed. This occurred with the codes of the more progressive Greek communities, which disembarrassed themselves with astonishing facility from cumbrous forms of procedure and needless terms of art, and soon ceased to attach any superstitious value to rigid rules and prescriptions. It was not for the ultimate advantage of mankind that they did so, though the immediate benefit conferred on their citizens may have been considerable. One of the rarest qualities of national character is the capacity for applying and working out the law, as such, at the cost of constant miscarriages of abstract justice, without at the same time losing the hope or the wish that law may be conformed to a higher ideal. The Greek intellect, with all its mobility and elasticity, was quite unable to confine itself within the strait waistcoat of a legal formula, and, if we may judge them by the popular courts of Athens, of whose working we possess accurate knowledge, the Greek tribunals exhibited the strongest tendency to confound law and fact. The remains of the orators and the forensic commonplaces preserved by Aristotle in his treatise on rhetoric, show that questions of pure law were constantly argued on every consideration which could possibly influence the mind of the judges. No durable system of jurisprudence could be produced in this way. A community which never hesitated to relax rules of written law whenever they stood in the way of an ideally perfect decision on the facts of particular cases, would only, if it bequeathed any body of judicial principles to posterity, bequeath one consisting of the ideas of right and wrong which happened to be prevalent at the time. Such a jurisprudence would contain no framework to which the more advanced conceptions of subsequent ages could be fitted. It would amount at best to a philosophy, marked with the imperfections of the civilization under which it grew up. Few national societies have had their jurisprudence menaced by this peculiar danger of precocious maturity and untimely disintegration. It is certainly doubtful whether the Romans were ever seriously threatened by it, but at any rate they had adequate protection in their theory of natural law. For the natural law of the jurisconsults was distinctly conceived by them as a system which ought gradually to absorb civil laws, without superseding them so long as they remained unrepealed. There was no such impression of its sanctity abroad, that an appeal to it would be likely to overpower the mind of a judge who was charged with the superintendence of a particular litigation. The value and serviceableness of the conception rose from its keeping before the mental vision a type of perfect law, and from its inspiring the hope of an indefinite approximation to it, at the same time that it never tempted the practitioner or the citizen to deny the obligation of existing laws which had not yet been adjusted to the theory. It is important too to observe that this model system, unlike many of those which have mocked men's hopes in later days, was not entirely the product of imagination. It was never thought of as founded on quite untested principles. The notion was that it underlay existing law and must be looked for through it. Its functions were in short remedial, not revolutionary or anarchical. And this, unfortunately, is the exact point at which the modern view of a law of nature has often ceased to resemble the ancient. The other liability to which the infancy of society is exposed has prevented or arrested the progress of far the greater part of mankind. The rigidity of primitive law, arising chiefly from its early association and identification with religion, has chained down the mass of the human race to those views of life and conduct which they entertained at the time when their usages were first consolidated into a systematic form. There were one or two races exempted by a marvelous fate from this calamity, and grafts from these stocks have fertilized a few modern societies, but it is still true that, over the larger part of the world, the perfection of law has always been considered as consisting in adherence to the ground plan supposed to have been marked out by the original legislator. If intellect has in such cases been exercised on jurisprudence, it has uniformly prided itself on the subtle perversity of the conclusions it could build on ancient texts, without discoverable departure from their literal tenor. I know no reason why the law of the Romans should be superior to the laws of the Hindus, unless the theory of natural law had given it a type of excellence different from the usual one. In this one exceptional instance, simplicity and symmetry were kept before the eyes of a society whose influence on mankind was destined to be prodigious from other causes, as the characteristics of an ideal and absolutely perfect law. It is impossible to overrate the importance to a nation or profession of having a distinct object to aim at in the pursuit of improvement. The secret of Bentham's immense influence in England during the past 30 years is his success in placing such an object before the country. He gave us a clear rule of reform. English lawyers of the last century were probably too acute to be blinded by the paradoxical commonplace that English law was the perfection of human reason, but they acted as if they believed it for want of any other principle to proceed upon. Bentham made the good of the community take precedence of every other object, and thus gave escape to a current which had long been trying to find its way outwards. It is not an altogether fanciful comparison if we call the assumptions we have been describing the ancient counterpart of Benthamism. The Roman theory guided men's efforts in the same direction as the theory put into shape by the Englishman. Its practical results were not widely different from those which would have been attained by a sect of law reformers who maintained a steady pursuit of the general good of the community. It would be a mistake, however, to suppose it a conscious anticipation of Bentham's principles. The happiness of mankind is, no doubt, sometimes assigned, both in the popular and in the legal literature of the Romans, as the proper object of remedial legislation. But it is very remarkable how few and faint are the testimonies to this principle compared with the tributes which are constantly offered to the overshadowing claims of the law of nature. It was not to anything resembling philanthropy but to their sense of simplicity and harmony of what they significantly termed elegance that the Roman jurisconsults freely surrendered themselves. The coincidence of their labors with those which a more precise philosophy would have counselled has been part of the good fortune of mankind. Turning to the modern history of the law of nature, we find it easier to convince ourselves of the vastness of its influence than to pronounce confidently whether that influence has been exerted for good or for evil. The doctrines and institutions which may be attributed to it are the material of some of the most violent controversies debated in our time, as will be seen when it is stated that the theory of natural law is the source of almost all the special ideas as to law, politics, and society which France during the last 100 years has been the instrument of diffusing over the Western world. The part played by jurists in French history, and the sphere of jural conceptions in French thought, have always been remarkably large. It was not indeed in France, but in Italy, that the juridical science of modern Europe took its rise, but of the schools founded by emissaries of the Italian universities in all parts of the continent, and attempted, though vainly, to be set up in our island, that established in France produced the greatest effect on the fortunes of the country. The lawyers of France immediately formed a strict alliance with the kings of the houses of Chapt and Valois, and it was as much through their assertions of royal prerogative, and through their interpretations of the rules of feudal succession, as by the power of the sword that the French monarchy at last grew together out of the agglomeration of provinces and dependencies. The enormous advantage which their understanding with the lawyers conferred on the French kings in the prosecution of their struggle with the great feudatories, the aristocracy and the church, can only be appreciated if we take into account the ideas which prevailed in Europe far down into the Middle Ages. There was, in the first place, a great enthusiasm for generalization and a curious admiration for all general propositions, and consequently, in the field of law, an involuntary reverence for every general formula which seemed to embrace and sum up a number of the insulated rules which were practiced as usages in various localities. Such general formulas it was, of course, not difficult for practitioners familiar with the corpus juris or the glosses to supply in almost any quantity. There was, however, another cause which added yet more considerably to the lawyer's power. At the period of which we are speaking, there was universal vagueness of ideas as to the degree and nature of the authority residing in written texts of law. For the most part the peremptory preface, Ita scriptum est, seems to have been sufficient to silence all objections. Where a mind of our own day would jealously scrutinize the formula which had been quoted, would inquire its source, and would, if necessary, deny that the body of law to which it belonged had any authority to supersede local customs, the elder jurist would not probably have ventured to do more than question the applicability of the rule, or at best cite some counter-proposition from the pandects or the canon law. It is extremely necessary to bear in mind the uncertainty of men's notions on this most important side of juridical controversies, not only because it helps to explain the weight which the lawyers threw into the monarchical scale, but on account of the light which it sheds on several curious historical problems. The motives of the author of the forged decretals and his extraordinary success are rendered more intelligible by it. And to take a phenomenon of smaller interest, it assists us, though only partially, to understand the plagiarisms of Bracton. That an English writer of the time of Henry III should have been able to put off on his countrymen as a compendium of pure English law a treatise of which the entire form and a third of the contents were directly borrowed from the corpus juris, and that he should have ventured on this experiment in a country where the systematic study of the Roman law was formally prescribed, will always be among the most helpless enigmas in the history of jurisprudence. But still it is something to lessen our surprise when we comprehend the state of opinion at the period as to the obligatory force of written texts, apart from all consideration of the source whence they were derived. When the kings of France had brought their long struggle for supremacy to a successful close, an epoch which may be placed roughly at the accession of the branch of Valois Angulsum to the throne, the situation of the French jurists was peculiar, and continued to be so down to the outbreak of the Revolution. On the one hand, they formed the best instructed and nearly the most powerful class in the nation. They had made good their footing as a privileged order by the side of the feudal aristocracy, and they had assured their influence by an organization which distributed their profession over France in great chartered corporations possessing large defined powers and still larger indefinite claims. In all the qualities of the advocate, the judge, and the legislator, they far excelled their compeers throughout Europe. Their judicial tact, their ease of expression, their fine sense of analogy and harmony, and, if they may be judged by the highest names among them, their passionate devotion to their conceptions of justice, were as remarkable as the singular variety of talent which they included, a variety covering the whole ground between the opposite poles of Cujas and Montesquieu, of Degas and Dumoulin. But, on the other hand, the system of laws which they had to administer stood in striking contrast with the habits of mind which they had cultivated. The France which had been in great part constituted by their efforts was smitten with the curse of an anomalous and dissonant jurisprudence beyond every other country in Europe. One great division ran through the country and separated it into pays de droit écrit and pays de droit coutumique, the first acknowledging the written Roman law as the basis of their jurisprudence, the last admitting it only so far as it supplied general forms of expression, and courses of juridical reasoning, which were reconcilable with the local usages. The sections thus formed were again variously subdivided. In the pays de droit coutumier, province differed from province, county from county, municipality from municipality, in the nature of its customs. In the pays de droit écrit, the stratum of feudal rules which overlay the Roman law was of the most miscellaneous composition. No such confusion as this ever existed in England. In Germany it did exist, but was too much in harmony with the deep political and religious divisions of the country to be lamented or even felt. It was the special peculiarity of France that an extraordinary diversity of laws continued without sensible alteration while the central authority of the monarchy was constantly strengthening itself, while rapid approaches were being made to complete administrative unity, and while a fervid national spirit had been developed among the people. The contrast was one which fructified in many serious results, and among them we must rank the effect which it produced on the minds of the French lawyers. Their speculative opinions and their intellectual bias were in the strongest opposition to their interests and professional habits. With the keenest sense and the fullest recognition of those perfections of jurisprudence which consist in simplicity and uniformity, they believed, or seemed to believe, that the vices which actually invested French law were ineradicable, and in practice they often resisted the reformation of abuses with an obstinacy which was not shown by many among their less enlightened countrymen. But there was a way to reconcile these contradictions. They became passionate enthusiasts for natural law. The law of nature overleaped all provincial and municipal boundaries. It disregarded all distinctions between noble and burgess, between burgess and peasant. It gave the most exalted place to lucidity, simplicity, and system, but it committed its devotees to no specific improvement, and did not directly threaten any venerable or lucrative technicality. Natural law may be said to have become the common law of France, or, at all events, the admission of its dignity and claims was the one tenet which all French practitioners alike subscribed to. The language of the pre-revolutionary jurists in its eulogy is singularly unqualified, and it is remarkable that the writers on the customs, who often made it their duty to speak disparagingly of the pure Roman law, speak even more fervidly of nature and her rules than the civilians who professed an exclusive respect for the digest and the code. Dumoulin, the highest of all authorities on old French customary law, has some extravagant passages on the law of nature, and his panegyrics have a peculiar rhetorical turn which indicates a considerable departure from the caution of the Roman jurisconsults. The hypothesis of a natural law had become not so much a theory guiding practice as an article of speculative faith, and accordingly we shall find that, in the transformation which it more recently underwent, its weakest parts rose to the level of its strongest in the esteem of its supporters. The 18th century was half over when the most critical period in the history of natural law was reached. Had the discussion of the theory and of its consequences continued to be exclusively the employment of the legal profession, there would possibly have been an abatement of the respect which it commanded, for by this time the esprit de lois had appeared, bearing in some exaggerations the marks of the excessive violence with which its author's mind had recoiled from assumptions usually suffered to pass without scrutiny, yet showing in some ambiguities the traces of a desire to compromise with existing prejudice. The Book of Montesquieu, with all its defects, still proceeded on that historical method before which the law of nature has never maintained its footing for an instant. Its influence on thought ought to have been as great as its general popularity, but, in fact, it was never allowed time to put it forth, for the counter-hypothesis which it seemed destined to destroy passed suddenly from the forum to the street, and became the keynote of controversies far more exciting than are ever agitated in the courts or the schools. The person who launched it on its new career was that remarkable man who, without learning, with few virtues, and with no strength of character, has nevertheless stamped himself ineffaceably on history by the force of a vivid imagination, and by the help of a genuine and burning love for his fellow men, for which much will always have to be forgiven him. We have never seen in our own generation, indeed the world has not seen more than once or twice in all the course of history, a literature which has exercised such prodigious influence over the minds of men, over every caste and shade of intellect, as that which emanated from Rousseau between 1749 and 1762. It was the first attempt to re-erect the edifice of human belief after the purely iconoclastic efforts commenced by Bayle, and in part by our own Locke, and consummated by Voltaire, and besides the superiority which every constructive effort will always enjoy over one that is merely destructive, it possessed the immense advantage of appearing amid an all but universal skepticism as to the soundness of all foregone knowledge in matters speculative. Now, in all the speculations of Rousseau, the central figure, whether arrayed in an English dress as the signatory of a social compact, or simply stripped naked of all historical qualities, is uniformly man, in a supposed state of nature. Every law or institution which would misseem this imaginary being under these ideal circumstances is to be condemned as having lapsed from an original perfection. Every transformation of society which would give it a closer resemblance to the world over which the creature of nature reigned, is admirable and worthy to be effected at any apparent cost. The theory is still that of the Roman lawyers, for in the phantasmagoria with which the natural condition is peopled, every feature and characteristic eludes the mind except the simplicity and harmony which possessed such charms for the jurisconsult, but the theory is, as it were, turned upside down. It is not the law of nature, but the state of nature, which is now the primary subject of contemplation. The Roman had conceived that by careful observation of existing institutions parts of them could be singled out which either exhibited already, or could by judicious purification be made to exhibit, the vestiges of that train of nature whose reality he faintly affirmed. Rousseau's belief was that a perfect social order could be evolved from the unassisted consideration of the natural state, a social order wholly irrespective of the actual condition of the world and wholly unlike it. The great difference between the views is that one bitterly and broadly condemns the present for its unlikeness to the ideal past, while the other, assuming the present to be as necessary as the past, does not affect to disregard or censure it. It is not worth our while to analyze with any particularity that philosophy of politics, art, education, ethics, and social relations which was constructed on the basis of a state of nature. It still possesses singular fascination for the looser thinkers of every country, and is no doubt the parent, more or less remote, of almost all the prepossessions which impede the employment of the historical method of inquiry, but its discredit with the higher minds of our day is deep enough to astonish those who are familiar with the extraordinary vitality of speculative error. Perhaps the question most frequently asked nowadays is not what is the value of these opinions, but what were the causes which gave them such overshadowing prominence 100 years ago. The answer is, I conceive, a simple one. The study which in the last century would best have corrected the misapprehensions into which an exclusive attention to legal antiquities is apt to betray was the study of religion. But Greek religion, as then understood, was dissipated in imaginative myths. The Oriental religions, if noticed at all, appeared to be lost in vain cosmogonies. There was but one body of primitive records which was worth studying, the early history of the Jews. But resort to this was prevented by the prejudices of the time. One of the few characteristics which the school of Rousseau had in common with the school of Voltaire was an utter disdain of all religious antiquities, and, more than all, of those of the Hebrew race. It is well known that it was a point of honor with the reasoners of that day to assume not merely that the institutions called after Moses were not divinely dictated, nor even that they were codified at a later date than that attributed to them, but that they and the entire Pentateuch were a gratuitous forgery, executed after the return from the captivity. Debarred, therefore, from one chief security against speculative delusion, the philosophers of France, in their eagerness to escape from what they deemed a superstition of the priests, flung themselves headlong into a superstition of the lawyers. But though the philosophy founded on the hypothesis of a state of nature has fallen low in general esteem, insofar as it is looked upon under its coarser and more palpable aspect, it does not follow that in its subtler disguises it has lost plausibility, popularity, or power. I believe, as I have said, that it is still the great antagonist of the historical method, and whenever, religious objections apart, any mind is seen to resist or contemn that mode of investigation, it will generally be found under the influence of a prejudice or vicious bias traceable to a conscious or unconscious reliance on a non-historic, natural condition of society or the individual. It is chiefly, however, by allying themselves with political and social tendencies that the doctrines of nature and her law have preserved their energy. Some of these tendencies they have stimulated, others they have actually created, to a great number they have given expression and form. They visibly enter largely into the ideas which constantly radiate from France over the civilized world, and thus become part of the general body of thought by which its civilization is modified. The value of the influence which they thus exercise over the fortunes of the race is of course one of the points which our age debates most warmly, and it is beside the purpose of this treatise to discuss it. Looking back, however, to the period at which the theory of the state of nature acquired the maximum of political importance, there are few who will deny that it helped most powerfully to bring about the grosser disappointments of which the first French Revolution was fertile. It gave birth, or intense stimulus, to the vices of mental habit all but universal at the time, disdain of positive law, impatience of experience, and the preference of a priori to all other reasoning. In proportion to as this philosophy fixes its grasp on minds which have thought less than others and fortified themselves with smaller observation, its tendency to become distinctly anarchical. It is surprising to note how many of the sophisms anarchiques which Dumont published for Bentham, and which embody Bentham's exposure of errors distinctively French, are derived from the Roman hypothesis in its French transformation, and are unintelligible unless referred to it. On this point too it is a curious exercise to consult the Moniteur during the principal eras of the Revolution. The appeals to the law and state of nature become thicker as the times grow darker. There is a single example which very strikingly illustrates the effects of the theory of natural law on modern society, and indicates how very far are those effects from being exhausted. There cannot, I conceive, be any question that to the assumption of a law natural we owe the doctrine of the fundamental equality of human beings. That all men are equal is one of a large number of legal propositions which in progress of time have become political. The Roman jurisconsults of the Antonine era lay down that omnes homines naturae equales sunt, but in their eyes this is a strictly juridical axiom. They intend to affirm that, under the hypothetical law of nature, and in so far as positive law approximates to it, the arbitrary distinctions which the Roman civil law maintained between classes of persons ceased to have a legal existence. The rule was one of considerable importance to the Roman practitioner, who required to be reminded that, wherever Roman jurisprudence was assumed to conform itself exactly to the code of nature, there was no difference in the contemplation of the Roman tribunals between citizen and foreigner, between freeman and slave, between agnate and cognate. The jurisconsults who thus expressed themselves most certainly never intended to censure the social arrangements under which civil law fell somewhat short of its speculative type, nor did they apparently believe that the world would ever see human society completely assimilated to the economy of nature. But when the doctrine of human equality makes its appearance in a modern dress, it has evidently clothed itself with a new shade of meaning. Where the Roman jurisconsult had written sequels sunt, meaning exactly what he said, the modern civilian wrote all men are equal in the sense of all men ought to be equal. The peculiar Roman idea that natural law coexisted with civil law and gradually absorbed it, had evidently been lost sight of, or had become unintelligible, and the words which had at most conveyed a theory concerning the origin, composition, and development of human institutions, were beginning to express the sense of a great standing wrong suffered by mankind. As early as the beginning of the 14th century, the current language concerning the birth state of men, though visibly intended to be identical with that of Ulpian and his contemporaries, has assumed an altogether different form and meaning. The preamble to the celebrated ordinance of King Louis Hutin, enfranchising the serfs of the royal domains, would have sounded strangely to Roman ears. Whereas, according to natural law, everybody ought to be born free, and by some usages and customs which, from a long antiquity, have been introduced and kept until now in our realm, and peradventure by reason of the misdeeds of their predecessors, many persons of our common people have fallen into servitude, therefore, etc. This is the enunciation not of a legal rule but of a political dogma, and from this time the equality of men is spoken of by the French lawyers just as if it were a political truth which happened to have been preserved among the archives of their science. Like all other deductions from the hypothesis of a law natural, and like the belief itself in a law of nature, it was languidly assented to and suffered to have little influence on opinion and practice until it passed out of the possession of the lawyers into that of the literary men of the 18th century and of the public which sat at their feet. With them it became the most distinct tenet of their creed, and was even regarded as a summary of all the others. It is probable, however, that the power which it ultimately acquired over the events of 1789 was not entirely owing to its popularity in France, for in the middle of the century it passed over to America. The American lawyers of the time, and particularly those of Virginia, appear to have possessed a stock of knowledge which differed chiefly from that of their English contemporaries in including much which could only have been derived from the legal literature of continental Europe. A very few glances at the writings of Jefferson will show how strongly his mind was affected by the semi-juridical, semi-popular opinions which were fashionable in France, and we cannot doubt that it was sympathy with the peculiar ideas of the French jurists which led him and the other colonial lawyers who guided the course of events in America to join the specially French assumption that all men are born equal with the assumption, more familiar to Englishmen, that all men are born free, in the very first lines of their Declaration of Independence. The passage was one of great importance to the history of the doctrine before us. The American lawyers, in thus prominently and emphatically affirming the fundamental equality of human beings, gave an impulse to political movements in their own country, and in a less degree in Great Britain, which is far from having yet spent itself, but besides this they returned the dogma they had adopted to its home in France, endowed with vastly greater energy and enjoying much greater claims on general reception and respect. Even the more cautious politicians of the First Constituent Assembly repeated Ulpian's proposition as if it at once commended itself to the instincts and intuitions of mankind, and of all their principles of 1789 inches it is the one which has been least strenuously assailed, which has most thoroughly leavened modern opinion, and which promises to modify most deeply the constitution of societies and the politics of states. The greatest function of the law of nature was discharged in giving birth to modern international law and to the modern law of war, but this part of its effects must here be dismissed with consideration very unequal to its importance. Among the postulates which form the foundation of international law, or of so much of it as retains the figure which it received from its original architects, there are two or three of preeminent importance. The first of all is expressed in the position that there is a determinable law of nature. Grotius and his successors took the assumption directly from the Romans, but they differed widely from the Roman jurisconsults and from each other in their ideas as to the mode of determination. The ambition of almost every publicist who has flourished since the revival of letters has been to provide new and more manageable definitions of nature and of her law, and it is indisputable that the conception in passing through the long series of writers on public law has gathered round it a large accretion, consisting of fragments of ideas derived from nearly every theory of ethics which has in its turn taken possession of the schools. Yet it is a remarkable proof of the essentially historical character of the conception that, after all the efforts which have been made to evolve the code of nature from the necessary characteristics of the natural state, so much of the result is just what it would have been if men had been satisfied to adopt the dicta of the Roman lawyers without questioning or reviewing them. Setting aside the conventional or treaty law of nations, it is surprising how large a part of the system is made up of pure Roman law. Wherever there is a doctrine of the jurisconsults affirmed by them to be in harmony with the jus gentium, the publicists have found a reason for borrowing it, however plainly it may bear the marks of a distinctively Roman origin. We may observe too that the derivative theories are afflicted with the weakness of the primary notion. In the majority of the publicists, the mode of thought is still mixed. In studying these writers, the great difficulty is always to discover whether they are discussing law or morality, whether the state of international relations they describe is actual or ideal, whether they lay down that which is, or that which, in their opinion, ought to be. The assumption that natural law is binding on states inter se is the next in rank of those which underlie international law. A series of assertions or admissions of this principle may be traced up to the very infancy of modern juridical science, and at first sight it seems a direct inference from the teaching of the Romans. The civil condition of society being distinguished from the natural by the fact that in the first there is a distinct author of law, while in the last there is none, it appears as if the moment a number of units were acknowledged to obey no common sovereign or political superior, they were thrown back on the ulterior behests of the law natural. States are such units. The hypothesis of their independence excludes the notion of a common lawgiver, and draws with it, therefore, according to a certain range of ideas, the notion of subjection to the primeval order of nature. The alternative is to consider independent communities as not related to each other by any law, but this condition of lawlessness is exactly the vacuum which the nature of the jurisconsults abhorred. There is certainly apparent reason for thinking that if the mind of a Roman lawyer rested on any sphere from which civil law was banished, it would instantly fill the void with the ordinances of nature. It is never safe, however, to assume that conclusions, however certain and immediate in our own eyes, were actually drawn at any period of history. No passage has ever been adduced from the remains of Roman law which, in my judgment, proves the jurisconsults to have believed natural law to have obligatory force between independent commonwealths, and we cannot but see that to citizens of the Roman Empire, who regarded their sovereign's dominions as conterminous with civilization, the equal subjection of states to the law of nature, if contemplated at all, must have seemed at most an extreme result of curious speculation. The truth appears to be that modern international law, undoubted as is its descent from Roman law, is only connected with it by an irregular filiation. The early modern interpreters of the jurisprudence of Rome, misconceiving the meaning of jus gentium, assumed without hesitation that the Romans had bequeathed to them a system of rules for the adjustment of international transactions. This law of nations was at first an authority which had formidable competitors to strive with, and the condition of Europe was long such as to preclude its universal reception. Gradually, however, the Western world arranged itself in a form more favorable to the theory of the civilians. Circumstances destroyed the credit of rival doctrines, and at last, at a peculiarly felicitous conjuncture, Ayala and Grotius were able to obtain for it the enthusiastic assent of Europe, an assent which has been over and over again renewed in every variety of solemn engagement. The great men to whom its triumph is chiefly owing attempted, it needs scarcely be said, to place it on an entirely new basis, and it is unquestionable that in the course of this displacement they altered much of its structure, though far less of it than is commonly supposed. Having adopted from the Antonine jurisconsults the position that the jus gentium and the jus natura were identical, Grotius, with his immediate predecessors and his immediate successors, attributed to the law of nature an authority which would never perhaps have been claimed for it, if law of nations had not in that age been an ambiguous expression. They laid down unreservedly that natural law is the code of states, and thus put in operation a process which has continued almost down to our own day, the process of ingrafting on the international system rules which are supposed to have been evolved from the unassisted contemplation of the conception of nature. There is, too, one consequence of immense practical importance to mankind which, though not unknown during the early modern history of Europe, was never clearly or universally acknowledged till the doctrines of the Grotian school had prevailed. If the society of nations is governed by natural law, the atoms which compose it must be absolutely equal. Men under the sceptre of nature are all equal, and accordingly commonwealths are equal if the international state be one of nature. The proposition that independent communities, however different in size and power, are all equal in the view of the law of nations, has largely contributed to the happiness of mankind, though It is constantly threatened by the political tendencies of each successive age. It is a doctrine which probably would never have obtained a secure footing at all if international law had not been entirely derived from the majestic claims of nature by the publicists who wrote after the revival of letters. On the whole, however, it is astonishing, as I have observed before, how small a proportion the additions made to international law since Grotius's day bear to the ingredients which have been simply taken from the most ancient stratum of the Roman jus gentium. Acquisition of territory has always been the great spur of national ambition, and the rules which govern this acquisition, together with the rules which moderate the wars in which it too frequently results, are merely transcribed from the part of the Roman law which treats of the modes of acquiring property jure gentium. These modes of acquisition were obtained by the elder jurisconsults, as I have attempted to explain, by abstracting a common ingredient from the usages observed to prevail among the various tribes surrounding Rome, and, having been classed on account of their origin in the law common to all nations / they were thought by the later lawyers to fit in, on the score of their simplicity, with the more recent conception of a law natural. They thus made their way into the modern law of nations, and the result is that those parts of the international system which refer to dominion, its nature, its limitations, the modes of acquiring and securing it, are pure Roman property law so much, that is to say, of the Roman law of property as the Antonine jurisconsults imagined to exhibit a certain congruity with the natural state. In order that these chapters of international law may be capable of application, it is necessary that sovereigns should be related to each other like the members of a group of Roman proprietors. This is another of the postulates which lie at the threshold of the international code, and it is also one which could not possibly have been subscribed to during the first centuries of modern European history. It is resolvable into the double proposition that sovereignty is territorial / that is, that it is always associated with the proprietorship of a limited portion of the earth's surface, and that sovereigns inter se are to be deemed not paramount, but absolute, owners of the state's territory. Many contemporary writers on international law tacitly assume that the doctrines of their system, founded on principles of equity and common sense, were capable of being readily reasoned out in every stage of modern civilization. But this assumption, while it conceals some real defects of the international theory, is altogether untenable so far as regards a large part of modern history. It is not true that the authority of the jus gentium in the concerns of nations was always uncontradicted. On the contrary, it had to struggle long against the claims of several competing systems. It is again not true that the territorial character of sovereignty was always recognized, for long after the dissolution of the Roman dominion the minds of men were under the empire of ideas irreconcilable with such a conception. An old order of things, and of views founded on it, had to decay. A new Europe, and an apparatus of new notions congenial to it, had to spring up before two of the chiefest postulates of international law could be universally conceded. It is a consideration well worthy to be kept in view, that during a large part of what we usually term modern history no such conception was entertained as that of territorial sovereignty. Sovereignty was not associated with dominion over a portion or subdivision of the earth. The world had lain for so many centuries under the shadow of imperial Rome as to have forgotten that distribution of the vast spaces comprised in the empire which had once parcelled them out into a number of independent commonwealths, claiming immunity from extrinsic interference, and pretending to equality of national rights. After the subsidence of the barbarian eruptions, the notion of sovereignty that prevailed seems to have been twofold. On the one hand, it assumed the form of what may be called fnfo sovereignty. The Franks, the Burgundians, the Vandals, the Lombards, and Visigoths were masters, of course, of the territories which they occupied, and to which some of them have given a geographical appellation, but they based no claim of right upon the fact of territorial possession, and indeed attached no importance to it whatever. They appear to have retained the traditions which they brought with them from the forest and the steppe, and to have still been in their own view a patriarchal society, a nomad horde, merely encamped for their time upon the soil which afforded them sustenance. Part of Transalpine Gaul, with part of Germany, had now become the country de facto occupied by the Franks. It was France, but the Merovingian line of chieftains, the descendants of Clovis, were not kings of France, They were kings of the Franks. Territorial titles were not unknown, but they seem at first to have come into use only as a convenient mode of designating the ruler of a portion of the tribe's possessions. The king of a whole tribe was king of his people, not of his people's lands. The alternative to this peculiar notion of sovereignty appears to have been, and this is the important point, the idea of universal dominion. When a monarch departed from the special relation of chief to clansman, and became solicitous, for purposes of his own, to invest himself with a novel form of sovereignty, the precedent which suggested itself for his adoption was the domination of the emperors of Rome. To parody a common quotation, he became aut Caesar aut nullus. Either he pretended to the full prerogative of the Byzantine emperor, or he had no political status. In our own age, when a new dynasty is desirous of obliterating the prescriptive title of a deposed line of sovereigns, it takes its designation from the people, instead of the territory. Thus we have emperors and kings of the French, and a king of the Belgians. At the period of which we have been speaking, under similar circumstances, a different alternative presented itself. The chieftain who would no longer call himself king of the tribe must claim to be emperor of the world. Thus, when the hereditary mayors of the palace had ceased to compromise with the monarchs they had long since virtually dethroned, they soon became unwilling to call themselves merely kings of the Franks, a title which belonged to the displaced Merovingians, but they could not style themselves kings of France, for such a designation, though apparently not unknown, was not a title of dignity. Accordingly they came forward as aspirants to universal empire. Their motive has been greatly misapprehended. It has been taken for granted by recent French writers that Charlemagne was far before his age, quite as much in the character of his designs as in the energy with which he prosecuted them. Whether it be true or not that anybody is at any time before his age, it is certainly true that Charlemagne, in aiming at an unlimited dominion, was emphatically taking the only course which the characteristic ideas of his age permitted him to follow. Of his intellectual eminence there cannot be a question, but it is proved by his acts and not by his theory. The speculative universality of sovereignty long continued to be associated with the imperial throne, and indeed was never thoroughly dissociated from it so long as the Empire of Germany lasted. Territorial sovereignty, the view which connects sovereignty with the possession of a limited portion of the Earth's surface, was distinctly an offshoot, though a tardy one, of feudalism. This might have been expected a priori, for it was feudalism which for the first time linked personal duties, and by consequence personal rights, to the ownership of land. Whatever be the proper view of its origin and legal nature, the best mode of vividly picturing to ourselves the feudal organization is to begin with the basis, to consider the relation of the tenant to the patch of soil which created and limited his services, and then to mount up, through narrowing circles of superfeudation, till we approximate to the apex of the system. Where that summit exactly was during the later portion of the Dark Ages it is not easy to decide. Probably, wherever the conception of tribe sovereignty had really decayed, the topmost point was always assigned to the supposed successor of the Caesars of the West. But before long, when the actual sphere of imperial authority had immensely contracted, and when the emperors had concentrated the scanty remains of their power upon Germany and North Italy, the highest feudal superiors in all the outlying portions of the former Carlovingian Empire found themselves practically without a supreme head. Gradually they habituated themselves to the new situation, and the fact of immunity put at last out of sight the theory of dependence. But there are many symptoms that this change was not quite easily accomplished, and, indeed, to the impression that in the nature of things there must necessarily be a culminating domination somewhere, we may, no doubt, refer the increasing tendency to attribute secular superiority to the See of Rome. The completion of the first stage in the revolution of opinion is marked, of course, by the accession of the Capetian dynasty in France. Before that epoch arrived, several of the holders of the great territorial fiefs into which the Carlovingian Empire was now split up, had begun to call themselves kings, instead of dukes or counts. But the important change occurred when the feudal prince of a limited territory surrounding Paris, usurped from the earlier house their dynastic title of kings of the French. Hugues Capet and his descendants were kings in quite a new sense, sovereigns standing in the same relation to the soil of France as the baron to his estate, the tenant to his freehold, and the old tribal appellation, though long retained in the official Latin style of the reigning house, passed rapidly, in the vernacular, into kings of France. The form of the monarchy in France had visible effects in hastening changes which were elsewhere proceeding in the same direction. The kingship of our Anglo-Saxon regal houses was midway between the chieftainship of a tribe and a territorial supremacy, but the superiority of the Norman monarchs, imitated from that of the King of France, was distinctly a territorial sovereignty. Every subsequent dominion which was established or consolidated was formed on the later model. Spain, Naples, and the principalities founded on the ruins of municipal freedom in Italy, were all under rulers whose sovereignty was territorial. Few things, I may add, are more curious than the gradual lapse of the Venetians from one view to the other. At the commencement of its foreign conquests, the Republic regarded itself as an antitype of the Roman Commonwealth, governing a number of subject provinces. Move a century onwards, and you find that it wishes to be looked upon as a corporate sovereign, claiming the rights of a feudal suzerain over its possessions in Italy and the Aegean. During the period through which the popular ideas on the subject of sovereignty were undergoing this remarkable change, the system which stood in the place of what we now call international law was heterogeneous in form and inconsistent in the principles to which it appealed. Over so much of Europe as was comprised in the Romano-German Empire, the connection of the Confederate States was regulated by the complex and as yet incomplete mechanism of the imperial constitution, and, surprising as it may seem to us, it was a favorite notion of German lawyers that the relations of commonwealths, whether inside or outside the empire, ought to be regulated not by the jus gentium, but by the pure Roman jurisprudence of which Caesar was still the center. This doctrine was less confidently repudiated in the outlying countries than we might have supposed antecedently, but substantially, through the rest of Europe feudal subordinations furnished a substitute for a public law, and when those were undetermined or ambiguous, there lay behind, in theory at least, a supreme regulating force in the authority of the head of the church. It is certain, however, that both feudal and ecclesiastical influences were rapidly decaying during the 15th and even the 14th century, and if we closely examine the current pretexts of wars, and the avowed motives of alliances, it will be seen that, step by step with the displacement of the old principles, the views afterwards harmonized and consolidated by Ayala and Grotius were making considerable progress, though it was silent and but slow. Whether the fusion of all the sources of authority would ultimately have evolved a system of international relations, and whether that system would have exhibited material differences from the fabric of Grotius, is not now possible to decide, for as a matter of fact the Reformation annihilated all its potential elements except one. Beginning in Germany, it divided the princes of the empire by a gulf too broad to be bridged over by the imperial supremacy. Even if the imperial superior had stood neutral, he, however, was forced to take color with the church against the reformers. The pope was, as a matter of course, in the same predicament, and thus the two authorities to whom belonged the office of mediation between combatants became themselves the chiefs of one great faction in the schism of the nations. Feudalism, already enfeebled and discredited as a principle of public relations, furnished no bond whatever which was stable enough to countervail the alliances of religion. In a condition, therefore, of public law which was little less than chaotic, those views of a state system to which the Roman jurisconsults were supposed to have given their sanction alone remained standing. The shape, the symmetry, and the prominence which they assumed in the hands of Grotius are known to every educated man, but the great marvel of the treatise De Jurabilii et Pads / was its rapid, complete, and universal success. The horrors of the 30 Years' War, the boundless terror and pity which the unbridled license of the soldiery was exciting, must, no doubt, be taken to explain that success in some measure, but they do not wholly account for it. Very little penetration into the ideas of that age is required to convince one that, if the ground plan of the international edifice which was sketched in the great book of Grotius had not appeared to be theoretically perfect, it would have been discarded by jurists and neglected by statesmen and soldiers. It is obvious that the speculative perfection of the Grotian system is intimately connected with that conception of territorial sovereignty which we have been discussing. The theory of international law assumes that commonwealths are, relatively to each other, in a state of nature, but the component atoms of a natural society must, by the fundamental assumption, be insulated and independent of each other. If there be a higher power connecting them, however slightly and occasionally, by the claim of common supremacy, the very conception of a common superior introduces the notion of positive law, and excludes the idea of a law natural. It follows, therefore, that if the universal suzerainty of an imperial head had been admitted even in bare theory, the labors of Grotius would have been idle. Nor is this the only point of junction between modern public law and those views of sovereignty of which I have endeavored to describe the development. I have said that there are entire departments of international jurisprudence which consist of the Roman law of property. What then is the inference? It is, that if there had been no such change as I have described in the estimate of sovereignty, if sovereignty had not been associated with the proprietorship of a limited portion of the earth, had not, in other words, become territorial, three parts of the Grotian theory would have been incapable of application.